All right, we are live on YouTube and I'm going to let everybody in. Good evening, everyone. This is the Renters Alliance Renter Town Hall. We'll get started in just a few minutes. If you're just joining us, this is the Renters Alliance Renter Town Hall. Takes a couple minutes to let everybody in the door. We'll get started in just a few minutes.
It's Kate is there.
Give it one more minute and then we'll get going. Okay, let's get started. All right, good evening, everybody. My name is Matt Losack. I'm co-founder and executive director of the Montgomery County Renters Alliance. Before I get to our special guest, I'll introduce our staff. We have David Mullins, our outreach director, Emily Towie, our Renters Alliance outreach coordinator, Tim Huang, outreach coordinator, and Pat Beckham, outreach coordinator. And Kate Stewart, staff member, Kieran Kochar, the last name, McCabe, is also listening in. And thank you all for joining us out there. A couple of instructions. If you have questions or concerns, please put them in the chat. Our staff will be looking there to monitor and give you a reply. We are going to run through some of the legislative initiatives that are happening in Annapolis after our guest goes over what she's doing. So stay tuned for that. And then we'll also be able to answer any questions and concerns you may have about your individual issues and whatever resources are available to assist you. But it is my pleasure and my honor to welcome one of our favorite council members who's been in this work for a long time, a renter champion for sure, the former mayor of Tacoma Park, and now the council member from District 5, if I got that right. 4. Used to be 5, but now it's 4. I don't know. Anyway, but we are so pleased to have with us Council Member Kate Stewart. Welcome, Council Member.
Thank you. Thank you so much, Matt, and everyone from the Renters Alliance and everyone who has joined us this evening. I really appreciate all of your time, and I'm excited to update you on a number of things, but in particular, a bill that we have coming up that will be introduced on March 5th. So I wanted to first give some background on what led us to this bill, first, many conversations with renters in our district and in Montgomery County. And I just want to do a huge shout out to the Renters Alliance, because it is bringing people together, and collectively, and hearing your voices and understanding your firsthand experiences, that really helps with the input on good legislation. And so it was it's basically all of you working with us that led to this bill. So it's called the Tenant Protection and Notification Bill. And two events really spurred this in the last year for us working on it. One was, and it's the anniversary of the Arrive fire. This past weekend, that was a fire in the building in downtown Silver Spring. Unfortunately, we lost Melanie Diaz in that fire, and many people were displaced during that. And, the Renters Alliance was instrumental in helping people think about ways to come together and have their voices amplified at this time. The other event that took place, and I was actually just there right before this meeting, was at the Grand, an apartment building in North Bethesda on July 29th of last year. As if you remember back to that time, we had a number of storms hit us, summer storms that knocked out the power in a number of places. And the Arrive has a generator to help keep on emergency lights, the elevators running, and other things. Unfortunately, in the middle of the night, the generator ran out of fuel, even though they're supposed to, under state law, have a certain amount of fuel available to them. And they did not call emergency services. Residents did not know what was occurring at that time. And it was only because one of our police officers happened to be in the 7-Eleven just down the street and looked up at the Grand and thought it looked kind of strange, because there were no lights on at all, and walked over there to find out there was absolutely no power and people were trapped on some upper floors, particularly some older residents who were on, needed oxygen and other medical devices. And the temperatures on the top floor of the Arrive were inching closer and closer to 90 degrees. And so we called emergency services in, and folks were taken care of, and thankfully no one was took seriously ill. But those two events, and listening to the experiences of people, and being with them the hours and days after that, had us take a look at what is in our code currently under tenant protections and notifications. And a couple of things that this bill does overall is, one, it looks at particularly fire safety, and how we can really increase people's awareness of their buildings. Delegate Charkoudian has been fighting hard in Annapolis at the state level to look at helping move forward with getting buildings sprinklers that don't have them. That's happening at the state level. But one of the things we want to do as we're continue to push that effort of getting sprinklers installed is making sure that if somebody is renting in a building, they know whether or not there are sprinklers in the building, and that this is clearly specified in the lease. One of the things that we heard from folks at the Arrive was, because they had been the building had been renovated fairly recently, they just thought there were these things like sprinklers in their units and hadn't really noticed that they weren't there. So we want to make sure that's clearly marked. Another thing that came out of the experience, and I know this is something that the Renters Alliance has been championing over the years, is on renters insurance, and how in many leases that can be really confusing for people. And so this happened at the Arrive. People had signed their leases and thought they had insurance. Well, it wasn't renters insurance. It was actually insurance for the building. It was their insurance for their landlord. And it wasn't clearly specified that they actually didn't have renter's insurance or insurance to cover their own personal belongings. And so many people lost everything in the fire, and they thought they had insurance, only to come to learn in the days after the fire that they didn't actually have renter's insurance and lost everything. And so that's something else that we need to have clearly specified in our leases so people know what they're covered for and what they are not covered for. In addition, kind of going back to the fire prevention, we want to have clarified general fire safety information, location of fire alarms, extinguishers, as well as evacuation plans. And an emergency plan that has to be developed and filed with emergency services for each building and shared with residents. In addition, another thing that when we looked at this section of our code, we wanted to see if there had been other changes in the county that we needed to make sure got updated. And as folks on this call may remember, the prior county council, actually Tom Hucker, the county council member, had led an effort to ensure that people had air conditioners in their rental units. And if it became, especially if the temperatures became above 80 degrees. Well, one of the things we noticed in the code is that we had a specification that if people's heat dropped, that they needed to be able to contact somebody and get that addressed within a certain time frame. But we hadn't updated the language now that we were mandating air conditioning. So that's another thing that we had put in place. And we were actually just talking to a gentleman at the Grand who didn't have air conditioning for quite a while, and this legislation would have helped him get air conditioning last summer. So that's kind of overall the bill. There are a couple of other things. I know we've gotten some, since we've shared the draft bill with a number of people in the community, including the Renters Alliance. There have been a couple of great suggestions on other things that we are looking at to possibly amend the bill as it goes through its process. At the moment, we are going to introduce this bill on March 5th. And we already have 6 council members who are co-sponsoring. So we have Councilmember Balcom, Katz, Sales, Mink, Albanaz, and Jawando, who have said they would co-sponsor, which since we can, the magic number is 6 to pass a bill. And that means with myself, we are at 7. So I think that's a great place to be. Once we introduce it, we'll get a date for the public hearing. And I know the Renters Alliance folks are all great at public hearings, and you can either come in person or do Zoom, and we'll give you the date for that if people want to give testimony at the public hearing. And in addition to that, there will be a committee assignment, and it will be reviewed by some of our committees and then go to the full council. And again, there's still opportunities to provide feedback, think of other things that we may want to include in that, and that can be addressed in amendments during the committee session. So I think
Councilmember Stewart, well,
Yeah.
what is, have you heard any opposition to it? What are they saying? If there is any?
at the moment we've just gotten more questions than any opposition. And I think because there are a lot of small things in this legislation, and then we're updating notification and being very specific. I think some people are just taking more time to understand what this would mean. So like another example, Matt, is like before there were a lot of things in our code that says, management has to be able, be reachable in an emergency in 24/7. Well, who defines what an emergency is? And at the Grand, when nobody had electricity and there wasn't even emergency lighting, the management company there didn't deem that an emergency. So we're specifying examples of what constitute an emergency that people had to be notified. So I think some of our colleagues are just taking a little bit more time to look at it, to understand the different pieces of it. We have shared it with folks like AOBA, HOC, MHP Enterprise, as well as with you all, to see for those folks who do manage properties, if there are things that feedback they want to give us. And so far, it's been fairly positive.
Okay, it's good. Just for full disclosure, our things we had suggested, the one thing in particular involved notice about criminal activity on the property.
Yeah.
And we hope some more consideration can be given to that. We are hearing, of course, and I'm sure you are, council member, about crimes that are taking place on apartment communities. And unfortunately, the communication from property managers or landlords is kind of sparse, if any at all. And tenants hear about it, they hear something happen, rumors begin to fly on one hand. And on the other hand, if there's a dangerous area in the community that has chronic problems of crime, then tenants also need to be informed about that. And as I say, historically, the e-property system, which is the county's public system where you can look and see what kinds of code violations are taking place on a property, what the landlord-tenant complaints are, used to also include police reports of what was also taking place on the property. So it's not unusual or not unheard of or unprecedented, but it's not something that's taking place now. And with crime on the uptick in a lot of places, I know tenants are calling for that. We are very interested in the idea of 24/7 contact for property managers, that somebody has to be there. We have seen just rampant, nobody home.
Yep.
On hold and nobody answering. And just what are your thoughts on what constitutes an apartment community emergency besides what we all know anybody should call 911 about?
Yeah, so in the bill, let me get to the page. We're it's an emergency, but also I want to say that we also talk about disruption of services. So if there's any disruption of services in electricity, water, heat, or a power generator, we wanted to specify that as well. Notice has to be given, and so that is there. I'm trying to find the place on the emergencies. So that, Matt, this goes to exactly what you were saying, that we actually looked at and said that somebody needs to be reachable 24/7, 7 days a week. So that's just like plain, like not even during times of emergency, that they have to be able to reach somebody in building management time. Yep.
Though I also imagine, with all fairness to the landlords, that if they're getting a call at 3 o'clock in the morning because of something that's not an emergency, that would be somewhat annoying. So we have to define it somehow.
Yeah, I mean, I think that could be, we can, so far again, we've sent this to MHP, Enterprise, AOBA. They haven't pushed back on that. I think it's, I want to think hard about like how we define that, because I don't want to I feel like we've gone so far in the other direction of not having management companies available to people, that I think we could try and get this one in and see if there is any issues, then we can go back and adjust it.
Well, and I imagine a landlord, if somebody were chronically calling them at 3 o'clock in the morning to say that they're hearing ghosts or whatever, that, eventually the landlord would be within their rights to say one more time and we're going to have a problem.
Yeah.
So
I would hope that landlord would then either contact us or contact, HHS, or provide assistance to that person, because if somebody's calling chronically at 3 in the morning, there's probably something going on in that person's life that we probably could connect them with services. So
right, and we'll bring you back to have the whole HHS discussion.
Yeah.
the time. Do we have any questions for Council Member Stewart?
Yeah, I think there's.
Yes.
Yeah.
Okay. Do you see it? Do you see it?
I see it. It's so I can read it for everybody.
Okay.
It says, I'd like to encourage the legislation to not only require landlords to disclose whether a building has, but also if it does provide information on plans and time frame to install sprinklers. Yes. This could further enhance transparency on efforts by landlords. Yeah. So thanks to, for that question. Yeah, that's where we're working hand in hand with Delegate Charkoudian. Some of this is state law, some of this is what we can do here in the county, and so we will look at that as well. But yes, how to address that is definitely top of mind for us.
Okay, and we have a thumbs up for the criminal reporting thing in the chat as well.
Yeah, and I think, just on that, we're looking at how best to put that into the bill. One of the things that we want to think about what we're actually requiring of landlords, because we also don't want them to share information that's inaccurate.
Absolutely.
Right. So, so we're saying, like,
Yeah.
so we want to make sure, think about working with our emergency services, working with DHCA and our police department to kind of think about how we would word what information they provide to make sure that they're providing also accurate information to residents.
In one of my past lives in the recent century, I was a communications director at a college, and they, by law, have to keep such records of criminal activity that takes place on the campus. And they also had to keep a central book that anybody could look at. But from an operational standpoint, what they had was a form, an incident reform.
Yep.
So in a way, it said, this is the information that you need to have, the accurate information you need to have. What time did it happen? What the nature of it was? Were police called? And what the follow-up, if any, was. But at least sort of a basic framework as to what took place, time and place, and where. And that way, with the turnover of property managers and so on that we're seeing all over the place, at least it would be a guide as to what it is that they have to do consistently.
Yeah.
Rather than make up a memo of what they think happened someplace.
Yeah.
So accuracy.
That's a great idea.
What else do we have for Councilmember Stewart? Everybody's quiet. You've solved the problem.
No.
Everybody, all the problems are solved. Thank you. We knew you could do it. That's why we voted you in. I suppose that you're also aware, though, of the governor's package. I saw that you had provided testimony in support of Just Cause Local Enabling.
Yep.
Presuming, though I won't put words in your mouth, that you will support it if and when it passes and comes to Montgomery County.
Yep.
But for everybody who doesn't know what that is, Delegate Janelle Wilkins, who's from Kate Stewart's neighborhood, has proposed legislation along with our board member, Delegate Vaughn Stewart, that will allow local municipalities like Montgomery County to enact just cause eviction protections. And they are, what a just cause does, it says that a landlord has to automatically renew your lease at the end of the term, with the exception, hopefully, of a modest rent increase, absent a good reason not to. Right now, they don't have to say why they're not going to renew. And we are seeing, unfortunately, a widespread number of retaliatory cases where people are being targeted for seeking promised or required services, for trying to form tenants associations, for simply pursuing their rights. And it is a big problem, and it is devastating to some people who have not done anything wrong, but are being forced out of their homes, some after many years of tenancy, being on time with their rents, abiding by the rules, being good neighbors, but because they asked for a better quality of life in the building or more adequate maintenance, or in one case, what we're dealing with now, Councilmember Stewart, is Arrive Wheaton, where the property management has targeted the entire leadership of the Tenants Association with notices to vacate. And it is, they have been problematic for quite some time, and we are dealing with it, but it is extremely dispiriting and has a massive chilling effect on the entire community when property management and landlords have that power to remove people, throw them out of their homes. There's very little defense against it. If you stay 1 day longer, the landlord gives you 60 days notice, you stay 1 day longer, you are in a status called tenant holding over. The
Mhm.
landlord then takes you to court for tenant holding over, and there's little or no defense. The only thing the landlord has to show is that they gave you 60 days notice, because they don't have to state a justifiable reason for having done so. What can you do? Even though we know that it was because these tenants were forming a tenants association or had formed one with our assistance, and were being retaliated against for that. And it's unconscionable. So anyway, we thank you, Councilmember Stewart, for your testimony that was submitted to in Annapolis. And we are also seeing a whole lot other pieces of legislation. Do we have anything else for, if you have a question or concern for Councilmember Stewart? I know that she probably wants to have dinner and be with her family, having spent all day in the council and then gone to a tenants meeting and now joined ours. But we have another minute with her if anybody has a question or concern.
Yeah, I think there's a question on, another question on fees. It's this person asks, our landlord, a large corporation, is imposing all kinds of fees, the latest being mandatory fee for internet access. They've signed a deal with Xfinity, and all tenants will be charged for the service whether we use Xfinity or have another internet service provider, like I do. Yeah, no, actually looking at fees is on our list of things that we need to dig into and understand better. We can looking at, like, this definitely is an issue when it comes to the cable and internet services. And we can, if you want to contact our office, it's at councilmember.stewart@montgomerycountymd.gov. Again, it's councilmember.stewart@montgomerycountymd.gov. And we can look into your specific issue to make sure that they're following everything. But fees we're seeing, thank you, Matt, for doing that. We are seeing fees come up in a lot of different ways. And it's that we need to get a handle on that. So yes, it's something that we want to look at on our team and see if we need to move forward with any specific legislation. One of the things we want to look at too, as we're doing, and I know, Matt, this is on your agenda too, to talk about the rent stabilization regulations, and think about, are there things in there that would address some of these issues as well. But it's
Have you had a chance to review the draft regulations yet?
I haven't dug into the draft yet. It's out for comment now. We've started looking at it, and then what will happen is, once the comment period is over, our director of DHCA in the county exec's office will look at them, revise them based on the feedback, and then we'll get them.
We've been poring over them, and we did meet with the director of housing and gave him some of our rough ideas, and we're going to put them into more specific recommendations this week, actually. Happy to share them with you if you care.
No,
But the regulations are going to be very, very important as the basically the predicate of the rent stabilization bill. And it takes into account fees.
yeah. And if I could, I see Judy from AIM is on the call. I just want to do a shout out to AIM, because I know the Renters Alliance just usually get involved when we do like zoning text amendments and other things when we're talking about the building of apartments. But we do have a zoning text amendment called Faith that has a public hearing on this Tuesday, and we're going to be doing a press conference. And AIM has been great in terms of helping us build support for that bill. What it'll do is help religious institutions or private education institutions, if they have property on which they would like to build affordable housing, to make it easier for them to do that. And so we've introduced that with Council President Friedson, and look forward into that moving forward, so that we can build more housing, both rental and home ownership throughout the county.
Yeah, people often wonder why we're not in that part of the narrative. First of all, we have our hands full with the one
Oh.
thing that we do, which is renters' rights and what happens to tenants when they move into their housing. But the building and development and that policy consideration is outside of what we do. We're interested in what happens to people when they get into their homes and how secure they are, the quality of life, and their rights. And that is strictly where we're focused. When we become a multi-million-dollar nonprofit with lots of staff with time on their hands, we might consider expanding our mission and policy focus, but not now.
Yep.
I will also say, Councilmember Stewart, we have proposed and have not gotten support yet from at least the executive's office, though there's some interest. But we are really urging that someone, maybe you, propose legislation that would require property managers and landlords to be trained and certified in order to work in Montgomery County in those positions. It would go a long way to preventing some of the mistakes that we have seen, some of the disputes between landlords and property managers and tenants, and some of the burden that's being put on us to help people navigate out of it, and on landlord, tenant, and code.
Yeah.
So many times we've seen complaints by tenants that perpetrated by a property manager just didn't know what she or he was doing. And then adding to that, best practices that, these folks are turning over all the time. Many of them, barely, have a driver's license, but are managing a 200 to 500 or 1,000 unit apartment community and have no significant training in how to do that. And with some of these properties having financial certification requirements, some of them with populations that have unique interests and needs of support, like senior communities. There are ways to manage these places, and we're not seeing enough of that. And so some places, I believe around the country, maybe I'm guessing, have this. I know some Southern Management, to their credit, used to have a program of training their people. So anyway, more of that would be a good thing if we're moving into the idea that managing a property of Gesundheit, of many, many people and families, you should really know what you're doing.
Yeah, no, I think it's a great idea and love to follow up with you on that and figure out how to do that. I know, from my experiences in, being the mayor in Tacoma Park, because we have actually, because we're Tacoma Park, we have some different laws in our city that sometimes the management companies weren't the people who were hired and working there didn't know about, and things like when we have non-citizens able to vote in our elections, or 16 and 17-year-olds, or the fact that candidates running for office can enter apartment buildings if they give notice. And I can say personally, I ran into some kind of sticky situations with some management folks in management who didn't know the rules, and quite frankly weren't upholding them. And making sure that people were getting information either about voting or allowing candidates into buildings to share information and things. So yeah, I think I would really like to follow up, and yeah, maybe that's our next bill.
Well, one of our favorite stories was when Vaughn Stewart was living in an apartment community downtown Silver Spring, and was before he was on our board, before he was a state delegate. He wanted to form a tenants association, which is how we got to know him. He had worked on Congressman Jamie Raskin's staff for a while. And so we invited Congressman Raskin and council member at the time, Mark Elrich, to have a tenants association meeting in the community room upstairs, which they are entitled to by law.
Yep.
And when we arrived, the property manager, George Wallace style, stood in the doorway and said, nobody's allowed to come in. And called the police. The police arrived and looked around and said, this is not our cup of tea. And they left. And the poor gal got an education from Mark Elrich and Jamie Raskin about what the law was. And then we had our tenants association meeting, but that should never have happened in the
Right.
first place.
Yeah.
So I think that we have run the gamut. Is there anything else you'd like to tell us about, Councilmember Stewart?
No, I think we did. Oh, actually, for people who live in the downtown Silver Spring area, this weekend is the opening of the new aquatic center. So we're very excited about that. It's
Well, I'm not promising I'll be there in my Speedo, but I'm definitely going to swim.
it's just it's gorgeous. It's not only, you know, swimming pools and that, but there's going to be more community spaces and other things. So really looking forward to that addition to our downtown in Silver Spring. So yeah.
Ribbon cutting is at 10, and I think it opens at 4 o'clock for anyone who wants to take a dip.
Yep.
And have you been inside it?
Just quickly, not lately, like before they've actually done a lot of work. So I'm
Is
looking.
it like a 50-meter pool or what is it?
Oh, I don't know. I'm
Is
not
it like one of those big pools?
a big
Like-
pool. No, it is
like-
actually, it is a big, it's a pool that I'm not a swimmer. So, but it's a whatever size pool, because one of the things is the hope is that this will also be a place where we can have swim meets and other things. And that will be also great for this part of the county, as well as our local economy. Because if we have teams coming in from other places and their families, they got to eat and enjoy our wonderful downtown Silver Spring.
Yeah, it's for a senior citizen, anybody over 55, and believe it or not, I'm there. It's $320 for the year for an entire annual membership. I think it's $400 if you're younger than 55, which is only about $10 a week or something like that. And also, of course, swimming is a terrific exercise. I'm really looking forward to taking a look at this facility, and I will definitely see you on the 24th, and I encourage everybody else to join us too. All right, with that then, Councilmember Stewart, thank you for joining us. Thank you for all your work championing renters' rights and supporting stable, affordable, quality homes in Silver Spring and in Montgomery County in general, and we look forward to following your work with great interest.
Great. Thank you all. Appreciate you.
Right. Thanks for coming. Okay. Let's talk about a few things that happened this week that are ongoing. As I mentioned earlier, we had a hearing on the Just Cause Local Enabling Bill that took place last Tuesday, I think. And of course, the Renters Alliance was there to testify. All of us were there to testify. And yesterday, the Governor Wes Moore, to our delight, proposed a package of bills that are designed to increase affordable housing, as well as establish a position in the Department of Housing and Community Development, a position that the Renters Alliance encouraged the formation of in our early conversations with the newly appointed Secretary of Housing, Jake Day, that would be focused entirely on advancing renters' rights. This is historic. We have not seen, certainly in my memory, any governor, certainly not Larry Hogan, and the previous governor, do anything to focus the administration on supporting stable, affordable, quality homes and security for renters. We've seen a lot in the housing development world, a lot that supports landlords, a lot of investment from time to time from the government to build more housing, which is great. If you're a developer, you will profit from that, and it's a good thing. But we haven't seen anything about protecting renters once they get into their homes. That is what the governor has proposed. He also, to our delight, took the position of supporting the Just Cause local enabling legislation. We had urged the governor to do that, and he has come out in favor of it and testified to it as well. There are several other bills. If any of you, David, if you want to weigh in on the Tenant Safety Act, I believe that's coming up next week.
Yeah, sure. I just put the link I put into, by the way, is for the governor's bill that would create that office of a tenant advocate and lower raise the filing fee for eviction filings. One quick note though on those, also the secretary, as Councilmember Stewart mentioned, the rezoning to allow faith communities to build easier. It sounded like the secretary for the affordable housing package was very focused on faith communities having access to funding too. So it sounds like there's some coordination there that's exciting. Yes, House Bill 1117 is the Tenant Safety Act. Our board member, Delegate Vaughn Stewart, has introduced again. And it's one of I think the key feature that I hear about most is that it would allow people who file a rent escrow case when they're not getting the kind of maintenance and services that they need. They're living in an unhealthy environment because of it. They can file with the court to pay their rent into escrow and to kind of force action there. That can be difficult, not just because people are afraid of retaliation, but just the barriers of the time of doing that. This would allow tenants to do that collectively, to make it easier to join cases together, those types of cases. So if there's a tenant association, that group could kind of approach the court together, and it'd make that a lot easier. But then I also noticed that it clarifies that mold was kind of questionable, I think, about whether that rose to the level of this. It clarifies that mold definitely does. And then it also calls for attorney's fees. So right now, the landlords can ask for attorney's fees for these failure to pay rent cases, et cetera. And then now for rent escrow cases, it kind of brings some parity to that and would allow for attorney's fees to be included in that as well.
Let me just also throw out, David mentioned that in the governor's bills, that would raise the filing fee. Right now, Maryland has about one of the lowest eviction filing fees in the country at about $15, whereas the national average is a little over $100. And many landlords are using our courts as kind of collection agencies, filing over and over and over again for small amounts of money when tenants may be late for any number of reasons, like Social Security checks coming late, or housing opportunity checks coming late, or whatever. But they're still caught up with their rent, but they're being forced to pay late fees and to go to court and miss days of work. So the idea was not to make filing so cheap that there wasn't a second consideration. And the second thing was, most importantly for us, is that increased filing fee must not be passed on to the tenants. So otherwise it would defeat the purpose of the bill. So instead of being $15, I think they said, was it $100, about $100. And that would not be passed on to the tenant. So that's going to be a very important part of the governor's package. And there was a whole lot on investing in new affordable housing as well. But again, that's sort of not our bailiwick. Our bailiwick is the renters' rights piece and just cause eviction protections. And the Tenant Safety Act is another one that we're looking at. And we also supported Delegate Laura Charkoudian's bill, which I believe would increase the tax benefit to tenants, seeing, I believe that part of our rent would be considered a payment of property tax, because we know that the landlords aren't paying property tax with their own money. They're paying it with the rent that we pay them. So we should also get part of the benefit of the tax write-off that comes with that. And that's Delegate Charkoudian. What other bills am I missing that we're working on? That's all I can think of right now. But if you're getting our newsletter, you did see a list of the ones that we're putting out, and we'll put out others as they come forward, just so people understand. The Maryland General Assembly meets from mid-January until mid-April. There are two houses, the House of Delegates and the Senate. Bills have to be proposed in one or the other house, but they ultimately have to pass both houses, and then they have to be signed by the governor. So we are hoping to see these bills get through first the committees. In the House, it's the Environment and Transportation Committee that handles housing. In the Senate, it's the Judicial Proceedings Committee that handles housing. And then after they are voted out of committee, hopefully with a favorable report, as they call it, then it'll go to the General Assembly for a complete vote at the end of the General Assembly term. So we have to monitor this. For all of you who are interested in these bills, and we hope especially on Just Cause, that you all contact not just your own state delegates, but every state delegate you can contact to say, please support these bills. The more they hear from you, the more likely they're going to understand that people are paying attention. The Just Cause bill, which we've been pushing now for, about 15 years, has gotten more support this year than it has ever gotten, but it's still not passed yet. So it does need to hear the voices of tenants who are paying attention and urging the passage of these bills.
I think I forgot
Okay.
to mention a quick note. Now that you say that the Tenant Safety Act is before that, like Matt mentioned, the Environment and Transportation Committee. There's a hearing on Tuesday about that bill. You have to sign up on Friday if you're trying to testify.
If you want to testify, okay. All right, let's move on then. Tim and Emily, would you walk us through the ULTA and code and what's available for people, just as reminders if they have concerns?
Yeah, so if anyone is having a kind of code enforcement issue, which could be something like something maintenance related, pests, mold, all that kind of stuff, you can file a complaint with code enforcement. And I can put that link in the chat. And they'll send an inspector out to check out your complaint. The other kind of complaint is for Office of Landlord-Tenant Affairs, ULTA, and those complaints are about landlord-tenant relations, like an excessive rent increase, problems with your landlord, lease disputes, things of that nature. And you can, same process where you can file a complaint that will go to ULTA, and then they can have an investigator look into that. And I'll put both of those links in the chat.
Okay, Tim, you have anything to add to that?
Don't think so. Covered it pretty well.
Okay, good. David, take us down the road of what we do a little bit as a reminder and a little bit about the ACE program.
Well, sure, and we're always here. We're gonna put our contact info in the chat, just info@rentersalliance.org for all of us. But then we'll put our individual emails in, because those processes that Emily just mentioned, along with applying for rent relief, these are not easy to navigate necessarily. So we do individual casework. We're here to connect with folks to try to start, direct to the right place. But then also, if there's some lack of response or dissatisfaction with the response, we try to help with that. But then more broadly, we're really very focused on organizing. I think some of the things that have come up already this evening related to collective action on escrow or other issues point to, and fear of retaliation. These things point to strength in numbers, safety in numbers. It's literally called the Tenant Safety Act, right? And so we, having a tenant association is something we try to support however we can. We always encourage folks to get with their neighbors, build that community, often around issues that are urgent or troubling. But then we really try to encourage people to have ongoing positive meetings, again, just to get to know their neighbors, and then to hopefully foster a good relationship with property management. Unfortunately, we hear a lot in these meetings sometimes about some of the bad actors and things, but we definitely have seen property managers who have taken the time to learn the law and get to know their residents who can have that kind of relationship. So we try to meet communities where they're at. So please, if wherever you are in that process, or if you have questions, we always want to hear about that. And you'll see us pop up in your apartment community, dropping a flyer for these town halls, and we're glad to help you flyer your property to invite people to these kind of meetings and things too. But then of course, then what Matt was talking about, we try to be at the state and local level aware of what's going on that's going to affect renters and direct people related to that. Oh, ACE. And then so the Access to Counsel and Evictions Program, ACE for short, is a state initiative funded by the state to provide free legal representation, to provide lawyers in housing court for tenants who cannot afford one. These are going to be low or moderate income is a requirement to qualify. The partners, it's statewide, but here in Montgomery County, the participating legal services agencies are the Maryland Legal Aid Bureau, and CASA has attorneys, and we can put their information in. The Homeless Persons Representation Project, HPRP, they're also involved. I don't know if they have any attorneys right now locally, but they are down at the courts. If you go on Wednesday, they'll make an announcement that there are lawyers floating around. You kind of have to go up to them, but they're there. They're for what's called same-day representation or to answer questions. But especially if your case is getting a little more complicated, things like tenant holding over, if you think there's been retaliation, things like that, you want to get in touch earlier if possible. So again, we'll drop the legal aid number in there. And then if you're at the court, then on the second floor there's the self-help center that has staffed by attorneys for walk-ins, and you can do consultations there. So if you want to kind of file your own motion or get questions about that you can stop by in person.
Did you all give an overview of our tenant association work too, David?
Yeah, I touched on it, and yeah, I'll just add on things like sample bylaws and things like that. We're glad to provide for those who are at that step. But no, yeah, but I did want to mention one more thing about the court from earlier, because the failure to pay rent had come up and eProperty. Just a reminder that we're not lawyers, but we know we've down there observing. We've seen enough cases. We're in touch with folks. I want to give a general reminder that if your landlord is not licensed, they can't be bringing failure to pay rent cases. And so that is something to keep in mind. And that's where eProperty comes in. You have the right to know whether your landlord is licensed or not. As difficult as that portal can be sometimes, eProperty has the information in there for most. So if you put your address in, you click the licensing tab, it should tell you. If it's ambiguous, let us know. We'll help you ask the licensing department from the county, which is separate from ULTA, but works with them. So please, yeah, that just remember that, because that they shouldn't be filing those cases in that situation.
Although, do keep one thing in mind, that if you're living in an unlicensed property and it's not up to code, and you make a complaint and code comes in and inspects the property and finds that it's uninhabitable or not legally inhabitable, it may unfortunately mean that you all have to move out. So balance your, pick your fights and balance your interests, and contact us. We know how to navigate this stuff and can advise you accordingly. Even though, as David says, we're not lawyers, we just act like them sometimes. Okay. I did want to give some reminders about, we touched on the rent stabilization bill. I want to remind people about what it is. The council passed last July a rent stabilization bill. It was signed by the county executive on July 24th. All legislation in Montgomery County has a 90-day grace period before it would take effect. After the 90 days with this bill, however, there was also the requirement that rent stabilization regulations be developed along with it. Regulations including, like, if you're a landlord who has some kind of hardship, how can you petition the county to circumvent the rent stabilization requirements? What kinds of fees can be charged? Because we are all concerned that if they can't raise the rent to a certain amount, then maybe they'll raise the parking fee. So there are regulations that had to be put in place or that are still being considered to make sure that the rent stabilization bill makes sense and has certain parameters to keep irresponsible landlords from circumventing it. We are poring over it. The rent stabilization regulations are available for comment. Emily has put that link in the chat. So we urge you to read it. It's I know it's a hard read. It's regulations. But they're important. And there are some things in there that we like, but what's going to happen now is that they have to stay in the county register for 30 days. They were put there at the end of January. They'll stay there till the end of February. And then they have to go to the county council, as Councilmember Stewart said, for consideration and a vote. We don't know how long that's going to take. We hope it will happen in March. There are a couple of amendments to the rent stabilization bill. We're very pleased that this bill passed, but we are by no means suggesting that it's mission accomplished. There was a whole lot of aspects to this bill that we fought against and will fight again when the time comes. One of them was the rent cap itself. The formula in the bill is 3% plus the county's CPI for housing. This year, the CPI was 5.8. That's the highest it's been in, as anybody can remember. But because of that, they put a cap at 6%. So 3% plus the CPI, in this case, would have been 8.5%, but they capped it at 6. Hopefully, in future years, it'll come back down to the average of 1 to 3%. So if it's 2% next year, and those guidelines will be coming out shortly in the next weeks, it might be 3% plus 2%, a 5% cap. But that has not taken effect yet. The other thing that we were opposed to was, as somebody mentioned in the chat, Deborah, the 23-year rule. We understand the principle behind it. We accept the principle behind it, that no one should invest $1 million or $100 million or $200 million in building an apartment community and not expect to make their money back and make a profit. We have no problem with that, and we wouldn't want to deter that kind of housing development. At the same time, 23 years is arbitrary to us. Who came up with that? Actually, Councilmember Don Lutke was the one who proposed the amendment, and we don't understand why 23 years. We get the principle, but we think it was probably, as the county executive had said, probably a lot closer to 10 years to make that kind of money back. And we would have allowed, if a landlord or developer were to show that after 10 years, they'd only made 40% of their money back and had to prove it, of course, then we would have said, all right, let's give them another 5 years or whatever it would take. But 23 years seemed arbitrary, and it is our belief that many of the apartment communities will have made their money back well before that 23-year period. The other unfortunate aspect of that is that there are thousands of apartment communities apartments that are in communities that have been built within the last 23 years, who will be exempt until the 23 years expires. If your building was built this year, you've got 23 years of exemption, according to this legislation. If it was built 22 years ago, you've got 1 more year of exemption. And we find that distressing, and we opposed it. Another amendment that Councilmember Lutke also proposed was that small landlords, 2 units or less, would be exempt. We don't understand why a smaller landlord should be any less responsible for stable, quality, affordable housing than a large landlord. So we don't get that. And also, unfortunately, there will be tens of thousands of Marylanders and Montgomery County residents who live in small apartment communities, 1 or 2 units, who will be exempt from this. And many of them are some of our most vulnerable residents. So the bill is by far not everything we wanted, but it is progress. And the struggle continues. So let us know if you have any questions or concerns about that. We will be putting our recommendations publicly eventually. Right now, we're just having conversations in good faith with the county executives, Department of Housing and Community Affairs, but stay tuned. This is very important stuff. What am I missing, David?
Oh, I was just going to top something off on the regulations piece of it, because we're just connected to earlier. Those of you that are concerned about fees and the regulation of fees, like Matt was saying, it's kind of thick, some of the regulation speak. It's at the end. It's the very last. So if you want to jump to the very last section, if that's really your main concern, and start there, it's a little easier to get through. And it's this particular draft, again, we don't know what will be adopted, but this particular draft is pretty clarifying as far as fees go. We've been trying to help some tenants navigate certain fees that are being charged recently, and pulling up both the state and the county law, the handbook together, it's a little wishy-washy. So this definitely adds some clarity there. I recommend y'all take a look and comment if you like that, if you think that's going to be helpful. Same thing for those of you that have been reaching out to us about 2-year leases, like a 2-year lease offering, being kind of unclear about the rent piece of that. That's addressed at the very beginning. Then, so if you want to just, if that's your concern, start. It's a very short piece at the very beginning of the regs, just a couple highlights.
Pat, do you have a piece of advice for all renters and all citizens?
Well, I have 3 things to say. The first is the young lady in the chat was wondering, could her carpet be replaced? Is she, I guess she's.
Let me address that one.
Okay.
Unfortunately, there is no requirement for a landlord to replace a carpet except if it becomes a tripping hazard. If it's a tripping hazard, that is, it's torn or sticking up because of something you did to it, then you're responsible for fixing it, or the landlord is going to charge you to fix it. If it's from normal wear and tear and just has worn through and is sticking up and becoming a tripping hazard, then the code department will force them to replace it. If it's just dirty and discolored, unfortunately, there's no law at this time that would require them, a landlord, to replace the carpet. We urge you to negotiate that. I think a good landlord, after a period of time, would do that for you, should do that for you, but there's no requirement that they do that for you. Unlike painting, a landlord, this is a flaw in the law and something that was on our list to fix, but you do have the right to have your apartment painted once every 5 years if you request it. So that does exist as it is now.
Okay.
Others?
Well, I just wanted to say Renters Alliance encourage all of these renters to get a renter association in their buildings.
Mm-hmm.
We think there is power in numbers, so that would be a good thing for everyone, we think. And secondly, we always encourage you to please vote. We need you to vote for people that can help us and help you. So when your time comes to vote, try to get your family to vote, speak to any council members you know, your church members. It's important.
Thank you, Pat. It is important to stay active. All that is happening that is advancing renters' rights are because of all of you and all of us who have been pushing our agenda in the courts, in the council, and in the state legislature, and for that matter, in the public at large. Just keeping people informed, increasing the knowledge of what rights you have and what rights you don't have, so that you're not surprised or prepared when the landlord moves against you or property manager violates your rights, that you know what to do and what it is it's necessary to fix. Okay, there's something else. There's a question about the courts. Lisa, tell us what it is. It's hi, thanks. I got court papers yesterday for November. The amount owed and was paid. I called the rental office, and that was what they told me. I'm assuming they told you that the amount was paid. It's not, well, okay, so let me tell you about court summonses. David or anybody can jump in. You receive a court summons for something that's inaccurate. This is how I got involved, by the way, in the renters' rights business a long time ago. I was working for the AFL-CIO, the labor movement. I was flying around the country. I put my rent check on the door of my refrigerator, and I left to catch a plane and forgot to pay the rent. I was in Chicago. I called the property manager. I said, I forgot to pay the rent. It's on the refrigerator door. I'll give it to you when I get back. They said, all right, but you're going to have to pay a late fee. I said, fine. How much? $25. So when I got back, I paid that month's rent, and I paid the next month's rent, and I paid the $25 late fee. 6 weeks later, I got an eviction notice. The eviction notice was sworn out in court and said that I hadn't paid that month's rent or the next month's rent. So that was not true. So by penalty of perjury, they had made a mistake. So I called the clerk's office and was advised to, first of all, make sure that the landlord knows that they've made a mistake. I got a letter from the attorney that signed the summons, since they had, in effect, been at least inaccurate, if they didn't actually lie, on a court document, to issue a letter of apology to me for providing something inaccurate. For those of you who receive summonses, you do need to make sure that you have verified that it has been dismissed. If the landlord says, don't worry, we're going to fix it, and it goes to court and you're not there, and nobody has dismissed it, or like they said they would, then you'll get a judgment against you, something that can't come off your record, even if it was inaccurate. So you have to call the clerk's office and verify that, in fact, it has been dismissed. We always urge you, if the landlord tells you it's dismissed or the lawyer for the landlord tells you it's dismissed, to get that in writing. So, this is serious business when it comes to your housing and your record. And so you have to sort of follow it through. So I would just check, since the court date has passed, Lisa, I think it was, I would call the clerk's office, the housing clerk, just call the district court, ask to speak to the housing clerk, and find out what the status of your case was and verify in fact that it was dismissed. If it was not dismissed and you did not show up, you've got a judgment against you, which is not a good thing.
I'll just add on top that it's a good time to remind people you have the right to see an understandable ledger of and your landlord is required under state law to do this kind of record keeping and provide it to you. And then, so if that, if there is a dispute about the amount, that day in court is the time to bring it up and ask. And if you believe you owe differently, bring your receipts. The judges are receptive, and then they will make the landlord bust out the ledger if there's a dispute. So that's your moment to do that. Keep that in mind. And then I think, did I paste the? Yeah, there it is. So I wanted to just highlight that those are the three I said I would paste in before: Maryland Legal Aid, HPRP, and CASA. Those are the three that are down at the court. Oh, and then one more reminder that that's your chance to talk about the rent amount, but these failure to pay rent proceedings are only that. So the judge will not hear complaints about conditions and things like that. You have to bring those actions separately. So just be prepared for that. And then a reminder that utilities are not rent. It is failure to pay rent. If you think there are other things being included, that's your chance to tell that to the judge as well.
It's a very important point that, when we fought this before, that utilities, parking, any amenity or whatever else you're paying, it's not rent. You have rent, which you're paying for your abode, for your home. That's rent. Anything else is not rent. And oftentimes landlords will put it all together and say that you're behind in your rent when actually you paid your rent fully. You just didn't pay your utility bill that much or something like that. And there's a different dispute than not paying your rent. Some of the danger that you have is if you pay it all together and you don't put in the check that this was for rent and this was for parking and this was for something else, then the landlord can take whatever part of the money that you gave the landlord and apply it wherever they want. So they could decide that we're going to pay the water bill that you didn't pay last month and put you behind in your rent, and then charge you a late fee when the rent is not paid by the 10th of the month. So being clear about what you are paying for is also very important. I'm very, very careful when I pay my rent that it says this is for rent and this is for parking and this is for water. Okay, anything else? Deborah, I would love to be able to clobber everybody with a class action lawsuit, but we don't see at this time that the rent stabilization is unconstitutional. But if you know a lawyer or you are one and you can recommend that this is something of that gravity, then we're all ears. But unfortunately, I don't see that happening at this point.
Probably worth mentioning when that comes up that all that stabilization bill talk, if you live in the city limits of Gaithersburg or Rockville or Tacoma Park, this particular bill, even once it takes effect, will not apply there. The city of Gaithersburg Council and the Rockville Council would have to pass their own rent regulation law.
Right. Worth noting, however, that Tacoma Park does have rent stabilization, had it before anybody else did. I think they were the first ones in the state of Maryland to have it. And it was in good part because Mark Elrich was on the Tacoma Park City Council. Okay, anything else, ladies and gentlemen?
There's one more question in the Q&A, which says, can you talk about brokerage fee or other fees added to monthly rent?
Brokerage fees. I'm not sure how that would relate to a tenant. So no, I can't talk about it because I don't know anything about it. You have a lease. Your lease is a contract and it says what you're responsible for. Not that a landlord can put anything they want in the lease. It has to be something that is legal and ultimately enforceable. We have seen leases where tenants in a senior building are also required to clean the gutters and mow the lawn. No, That's not something that they're required to do because the landlord was using an old lease from another property. We also saw a provision in the lease that said, if you're falling asleep in the community chairs, you can be evicted. No, that you can't do that either. But I don't know about broker. If they're saying, listen, you've got to pay the landlord or the owner of the property has invested in General Electric and there are brokerage fees that you have to pay for. I've never heard of that before. So no, I'm not thinking that that's an issue. Anybody else got a different take on that question?
Why we had a broker when we rented an apartment in New York to help us find the apartment, had to pay them a fee. But I think I haven't run into someone trying to do that kind of. I have a feeling that's not allowed here.
Oh,
But
I'm sorry. Then I apologize for being on the wrong tangent. You're talking about a real estate broker. And so, yeah, I guess so. It depends on what the agreement is. In my experience, first of all, it's whatever the lease says. If, everything should be up front. So, if the landlord says, I'll lease this apartment to you for $1,500 plus the $200 that's going to the real estate broker or the realtor, I'm not sure that is something that is illegal, but it should be fully disclosed to you as a choice of whether to take the place or not at the outset. If it's a brokerage fee every month, it doesn't make any sense to me because I would think that the landlord would simply have the total rent that would include the brokerage fee and the landlord would pay the broker. So I'm not exactly sure what that is, but it is interesting that you raise it because if brokers are involved as part of the leasing of an apartment, we would not want to see that as a way to circumvent the rent stabilization law.
No, I think it would be a upfront thing, and I think the state law on lease application fees, if the landlord's the one trying to charge it, we should revisit this because I think it would probably fall under you can't do anything more than the $25 fee. Everything else has to be refundable. But if you're paying just directly some third party who helped you find an apartment, I mean, that could be a gray area. I don't know.
Yeah, I mean, especially a one-time payment, I might seems more reasonable than actually in some broker, for a real estate broker, if you're selling a house, they get a one-time fee at the time of sale. But in an apartment situation, they might get a piece of the rent for 1 year, 2 years, or a period of time. But I'm not sure what the legality is in terms of who pays. And I don't know that it would be illegal. Again, we're not lawyers. If that were disclosed to you at the outset as part of the lease. I really don't know, but we'll take a look at that and see what in fact the law is. Anything else? Then I will say happy Wednesday. Couple reminders. Our next town hall is March 6th, and we will have a discussion on tax relief for renters with our partners at the Housing Initiative Partnership and other guests at that time. And then we are pleased to say that on March 20th, we will have the new Secretary of Housing for the state of Maryland, Jake Day, who will join us to discuss the governor's bills and what progress he has made heading up the Department of Housing and Community Development. That's the state housing department. So with that, thank you everybody for joining us this evening. Thank you, Councilmember Stewart, for joining us, and good night to everybody.